letters from the Juga family, from supporters of theirs, describing the level of loss that they feel, the level of pain, physical and emotional. And so I'm not going to pretend to understand what that is. I can appreciate that life would never be the same going through this situation. If this had happened to one of my children, I would be an absolute mess. I would be a disaster. I would be filled with rage. I would be filled with anger. I would be overcome with sadness. I have no doubt that that would be the case. But that's why if that had happened to me or someone that I love and that I was close with, the decision about what the punishment should be would not be mine to make. It falls to a judge. To listen to all sides of this case, to act impartially, to take the emotion out of the situation, decide what is fair, and decide what is just. And that's part of the heavy load that is given to judges, to use their judgment, to not be scared of criticism, to not be scared of the public, to not be swayed by those things. At the trial, in my closing argument, I said to the jury that part of what their job was to not be swayed by sympathy, prejudice, or passion. I understand this is not the trial and you are not the jury, but I think that that sentiment continues to hold true. Mr. Gravely talked about remorse. A number of the letters talk about, from the Juga family and their friends and supporters, talk about the lack of remorse that Martice exhibited. And I think Mr. Gravely is accurate in saying that it would be hollow if he did, and I think that's true. I don't think that even if that had occurred, even if there had not been a trial, I don't think it would have made anyone feel any better. I don't think anyone would have believed Martice. They have every right to be mad at him. They have every right to hate him. And I think the reality is that there's nothing that he can do to change that and to change that opinion. I think that all too often we ask way too much of the criminal justice system. We ask the criminal justice system to provide a fair trial, to provide due process, to honor a defendant's constitutional rights, to figure out the correct punishment. And we also use it to try and find healing for victims of crimes or the community. And that's really not what it was designed to do. And I think it's asking too much of the criminal justice system to provide that healing and that closure, because that's not what its original design was. In May of 2019, Martice Fuller was 15 years old. He had no juvenile court history. He was an honor roll student. He was a varsity athlete with lots of potential. He was working part-time jobs. He was a talented young man with a bright future before him. And the courts received a number of letters from his family and his friends describing that person and that child. And I understand that what's been presented to the court in the trial is a completely different message. But I don't think that that discounts what his family and friends have said about him, about who that person was and who that person is and continues to be. I wanted to respond to a couple of things that the state had mentioned. One was a letter that was sent from the jail to the Juga house. And I just want to note that that matter has not been litigated in a court. There's not been an opportunity to challenge that, I guess, in the formal setting or in the correct setting. And Mr. Gravely made a number of comments about how the Fuller family has some of the things that have been said now at this point. And there's certainly, this case is not about what they did or did not do. I cannot think that there's a way to accurately predict how any of us would react in a crisis situation such as what they faced. And I don't think whether they believe the state's evidence about what happened or didn't happen, I don't think that's the issue today. The issue is, what's the correct sentence? What's the appropriate punishment? I know the court is well aware of what its obligations are, what the Galleon factors are. And part of sentencing is to figure out what's the appropriate sentence. I know in most cases the court has to first consider probation. We're not in that situation, I understand that. But I think that what the inference is from the case law is to say that the court is to impose the sentence that is the least restrictive needed to accomplish its goals. And here we believe that that means release at some time in the future. The legislature could have decided that anytime someone is convicted of first-degree intentional homicide, that they can never be released from prison. That's not what they did. They said that a judge can decide that at some points in the future that someone is eligible to petition for that release, that it's possible to do that. And here we have a child. We have someone who is 15 years old in May of 2019, who less than a week ago turned 18. And as is mentioned in the sentencing memorandum, the United States Supreme Court has talked about the differences between adults and children when it comes to sentencing, and that even when juveniles commit terrible crimes, they should not receive the harshest sentences, such as the state's proposing. That children are different. Their character is not as well formed. Their traits are less fixed. And, quote, from a moral standpoint, it would be misguided to equate the failings of a minor with those of an adult, for a greater possibility exists that a minor's character deficiencies will be reformed. And so, Your Honor, we're asking you to make Martice eligible for release in 25 to 30 years. He is a child, and I do think, and the Supreme Court has recognized, that there is a greater possibility, greater potential for reform. To give some type of reason to be better, to do better, for hope. And the state was right. I'm going to mention hope. To give someone who is 18 years old some ability to think that one day they may be able to walk in the world, to do something, a small thing, to make up for the tremendous pain and sorrow that they have left behind them, and to allow them that opportunity. And so that is our request, and our recommendation of the court is to make Martice Fuller eligible for release in 25 to 30 years. Thank you.
Thank you, Mr. Johnson. Mr. Fuller, anything you'd like to add?
Judge, Mr. Fuller's prepared a statement that he asked that I read on his behalf.
Okay. As you know, court reporter, read slowly, okay?
Yes. Martice writes, wholeheartedly, I wanted to write this giving my sincerest apologies to this family I once shared time and love with. Truthfully, I am sorry about the pain you've all suffered through but more importantly, the loss of my ex-girlfriend, Kaylie, that I loved too. So I am sorry. Despite the hatred that is against me, I still am sorry. But I have to continue to stand innocent because I am. And I know that I've barely showed emotion throughout my time, But in all honesty, it is because it's hard to have tears left to cry knowing my mom lost a son, one of her children too. But I am sorry, and I hope you all can eventually see in your hearts and vision that I am not the person the media has made me out to be. Thank you for the chance to hear me out.
Thank you.
Your Honor, I believe the defendant has been incarcerated for 743 days.
Thank you.
And we ask that restitution be to be determined.
Any objection to that?
No.
Okay. Today is a final day for me in this tragedy that you, Martice, caused for this family, the family of a young girl that you murdered, a mother and a wife that you attempted to murder, and their family, and a community that watched in horror as the story of your ruthless, depraved, and violent story unfolded. It was unfathomable for all of us to think that a boy 15 years old could plot and plan ruthlessly to kill Kaylie and her mother. There's no final day for them, their loved ones, or for your own family. Your actions killed a young girl, wounded and scarred a mother, damaged 2 brothers and a father, and that damage will not end emotionally, physically, or societally. Their burden is enormous and endless. This was a family that warmly admitted you into their circle of family and friends. They ate with you and included you in family activities. They were good to you. They considered you a friend of their daughter. And when teenagers of all ages choose to date and be with friends with other people, you decided you would not allow Kaylie to make that choice. A choice of adolescent friendship that probably every person in this room has made many times before they marry as an adult. Instead of enjoying that friendship that you had, you decided it would be terminated, like a hitman. We saw the plan, the calculating moves that you made to carry out your hatred and your vengeance, the efforts to cover up your heinous act. We also saw the decency of a community in testifying in this case. We heard of the efforts of the school district to put an end to your controlling and compulsive efforts to wall off this young girl from others. You would have none of it. I saw you assert your constitutional rights in a trial that you had every right to do. But I watched as Mrs. Juga, the woman you attempted to kill, testified bravely while you showed not one semblance of compassion or remorse. You sat emotionless until the verdict was returned. You seemed to have no ethos, no regret, no sorrow, no empathy. You are for you and no one else. Much time has passed, and now you're 18. And what have you done since then? You attempted to tamper with my jury. You gathered other inmates to brutalize other inmates. I don't have any knowledge about this other letter, but certainly that isn't a star. You have not shown any attempts to acknowledge your wrong or express remorse in your actions. You are a very dangerous and a damaged human being. You have the soul that God gave each one of us, but it seems it is not bent toward compassion, kindness, or remorse. I'll pray that it be repaired in some manner, but I don't hold the solution for it. These crimes were not the impulsive acts of an undeveloped child. These acts were performed deliberately and with much thought and planning. You do not stand before this court with a damaged childhood. You don't have a history of mental illness. You're intelligent, you are socially developed, you are athletically gifted, you have no prior record. People believed in you and your talents and your future. Your parents worked on your behalf to raise you well. You rejected them. You rejected the coaches who could have helped you. You rejected the school's directions. You rejected the rules of society. And you rejected the rule of law in the processing of this case. The taking of a human life is the most serious of crimes, which is why the legislature has said it statutorily as they have. The attempting of taking the life of Mrs. Juga was a continued part of your plan to cover your murder of Kaylie, and luckily for her, you ran out of ammunition. I don't have any ability to trust that you will never commit these acts again. You continued violent behavior in the jail. The court has no trust whatsoever that what brought you to this murder and attempted murder is repaired or repairable ever. Rehabilitation is not likely in my mind. I hope that you can right yourself in your life, in your daily life, but it won't be among the community. It was all too calculated. So in the interest of protecting the public, acknowledging the seriousness of these acts, the court orders that on count 1, you are sentenced to life in prison without eligibility for extended supervision. You are, on count 2, the court is ordering 15 years in prison, followed by 6 years of extended supervision, consecutive to count 1. And on count 3, the court orders 5 years of initial confinement and 3 years of extended supervision. Count 2 and 3 are concurrent with each other, consecutive to count 1. You are convicted of a felony. The law prohibits you from ever owning or possessing a firearm. If you are found to own or possess a firearm, you would be charged with felony offense, which carries 10 years in prison and a fine up to $25,000 or both. You're required to submit your DNA sample if that has not already been accomplished. You're not eligible for most of the programming because of the nature of these offenses. And I'd ask that Mr. Johnson and Ms. Scheidegger please accompany him to the go over post-conviction in the other room. Credit for 742 days, and restitution is held open.
Thank you, Your Honor.
You're welcome. Now, everybody's going to sit tight till we get an orderly way to vacate the courtroom. Heidi? I don't have that consecutive and concurrent marked very well, but you could probably do it.